Maggio Como, good morning.
Please, the court, Mr. Chief Justice, Justices, Joseph Magiacomo, on behalf of Lawrence Heywood. Bear with me a little bit, I'm going to have to push on an eye to see. I forgot my glasses, and that's how I focus when I'm getting old is tough. With reference to Mr. Heywood, Judge, I would respectfully suggest that the judge committed reversible error in not excusing the blind juror for cause.
If you want to, you can move your papers closer to you.
But that's okay, Judge.
You're
No
okay?
matter what, it's,
Okay,
as long as I push over here, it works.
okay. Just a reasonable accommodation.
It is, Judge. Long as, I think we all would agree that Article 12 in the Sixth Amendment guaranteed the right to an impartial jury, and fundamental within that right is that the jury be competent, qualified, and able to comprehend and intelligently resolve the factual issues. I think we'd all agree that 234, Section 28, does give a trial judge discretion to exclude a juror who he believes is not competent to serve because of a physical disability. Now, I'm not suggesting in this case that all blind jurors are incompetent to serve. I think Mr. Heywood's case is a unique case in that the judge did commit reversible error in this case. There's no doubt that the judge asked the juror if he would feel comfortable with another juror telling him what the photographs depicted and also reading to the juror the medical information. Now, I'm sure my sister is going to argue that this is harmless error because there was testimony with reference to the serious bodily injury. But
I guess the danger is trying to intrude upon what happens in jury rooms, but isn't this what happens every day in jury rooms? We have exhibits and one juror may read the medical reports and they may say, hey, I just noticed this.
But the other jurors have the ability too. And in this case, where you have an issue of serious bodily injury, I would respectfully suggest to the court that the subtleties that go along with that, and although we did have testimony pertaining to Mr. Spencer's jaw having to be reconstructed and things of that sort, what constitutes serious bodily injury is an individual analysis by each individual juror who brings their background to the court.
What would the juror have observed? What would the jurors have observed that the blind juror couldn't observe?
Well, the jurors would have observed the pictures of the victim.
Well, it looks okay now, right?
Looks okay now, but they would have observed the pictures of the victim at the hospital. They would.
Why do you need that as opposed to testimony?
Please?
Why do you need that as opposed to testimony?
Because it goes to the underlying fact that I was just going to state, Justice, with reference to we bring our individual common sense and our experience to the jury room, and what one juror believes constitutes serious bodily injury, another juror might not. Now, myself, I'm older now, but when I was in my 20s, I was a law enforcement officer in the 90s in Miami. So I saw a lot of bad things. I became immune to things. What I believe constituted serious bodily injury would be wholly different from I would suspect a suburban individual who's never been exposed to any violence.
The danger is you're excluding a whole class of individuals based upon their ability to see from jury service.
You're not excluding, and I think the amicus brief touched on this very poignantly with a lot of great suggestions. You're not excluding a juror per se. You may be excluding a juror from certain cases.
So any case involving photographs, no blind jurors. Every case, as you well know, in the Superior Court has a videotape nowadays. Surveillance video is in basically every case.
I don't think we can stretch the analysis to every case that has pictures, because some pictures may be irrelevant in and of itself to a scene, but the Commonwealth decides to put them in. Some pictures may not go to the underlying elements of the offense. An OUI, so
But if there's a
a,
photograph of the roadway that's twisty and bendy, you're gonna say, well, how could the jurors see the twisty, bendy roadway?
well, that would come in through testimony, Judge, and does it go to, whether the roadway is twisty and bendy, does it go to the element of the offense of operating under the, of being impaired?
Doesn't this just call for that individualized assessment that the judge did in this case?
I think that the judge is right in doing the individual assessment. I think the case law and 234, Section 28 is correct in giving the judge discretion. In this sole case, where the jurors were required to look at pictures of what Mr. Spencer looked like immediately after the battery, and then viewing what he looked like as he testified to make a determination whether there was scarring or whether any residual effect that could be
Testimony.
seen.
Theory,
Please?
Sorry.
please.
I was going to say, wasn't there testimony to this effect?
There was testimony to the
And was there
effect-
any objection to this, by the way, to this juror?
No, there wasn't, and there is an IAC claim, which I will just rest on my briefing with that, because I think in the 15 minutes, they're much more important.
Counsel, we can't force, even if everybody on the juror had a perfect sight, we can't force each juror to look at the picture, can we? To really look at it the way you want them to really look at it?
I don't think the question should be presented as forcing the jurors to look at them or not. I believe the question should be whether Mr. Heywood was afforded his Article 12 and Sixth Amendment right by having a juror that did not have the ability to examine all the evidence without what we would all have to assume is extraneous evidence being presented. None of us know what was presented, if in fact anything was presented by the other jurors.
How's it
And-
extraneous if another juror, so if I'm on the jury and I have a stack of medical records, and Justice Budd is my fellow juror, and she says, well, what do they say about the paranoid schizophrenia? I said, well, he was diagnosed with paranoid schizophrenia in 1984 at Bridgewater, right? So I say that to my fellow jurors. Is that extraneous?
No, that would not be extraneous, but we don't know what was said.
But when you say
And-
extraneous, you have to be very careful.
You do,
But
and
if it's an exhibit in the jury, how is it extraneous in the jury room?
the exhibit in and of itself is not. How it may be described may very well amount to extraneous evidence. And I again believe that amicus had some very good suggestions on this. And I realize, with all due respect, that we are in the Stone Age compared to when I practiced right out of law school in Florida that had all the Disney money and technology was great. We are just getting there. But you know, amicus gave some very good points as to how we could have certified people to describe pictures, things of that sort. We're not there yet, so what I would suggest to the court is that the judge created a situation where there was the possibility of extraneous information coming in by the mere fact that the judge said to the juror that he could have other jurors describe the pictures and other jurors read the medical reports. And we all would like to live in a perfect world and rely on the fact that a juror would read verbatim what is in that report to another juror. But if there are 6 people in that jury room, and you have 2 people talking about one thing and 2 people talking about it, or 3 people talking about another, and they're not all paying attention to one another at that point in time, then I think we would be remiss to say that if someone read something the wrong way or depicted something the wrong way, the other jurors would pick up on that.
Yeah, there's a lot of really important issues, big picture issues to think about with this case, and the amicus brief from the National Federation of the Blind is wonderful in helping us think about that. But we just focus on this particular case for a moment, and there's no objection, as Justice Lang said. So, substantial risk of miscarriage of justice here. You've got an issue of serious bodily injury. And it's not like the jurors from the jury box can observe the victim and say, oh, I see the serious bodily injury there. It's got a titanium plate that's holding up his face. The issue is not what the juror is seeing on the witness stand. So the question, I'm not saying that we shouldn't talk about, because we absolutely should talk about the big picture issues here. But as it relates to this case, how can there be a substantial risk of miscarriage of justice when the jurors weren't observing the witness to decide visually at that moment whether there was serious bodily injury?
I would suggest, Your Honor, that, number one, we're operating under the premise that there is no visual disfigurement or scarring, and whether there is or not, none of us will ever know because it wasn't brought out by the Commonwealth. Again, titanium plate in and of itself, whether that constitutes serious bodily injury,
Well, you'll tell us your view of that. That doesn't answer my question. That's the theory. Maybe your other argument about sufficiency of the evidence is right, but that's the theory. So what the jury is observing of the witness is not the key to whether or not the burden of proof has been satisfied on what constitutes serious bodily injury.
What you're suggesting is that the violation of the second prong of an IAC claim was harmless, and I would respectfully disagree because scarring and disfigurement are also part of serious bodily injury, number one. Number two, if in fact there was no scarring or disfigurement, the jurors were still asked to look at photographs of Mr. Spencer immediately preceding the assault, and whether that constituted serious bodily injury or not, Mr. Heywood had a right to that juror being able to see those.
I'm confused how that would work, because you have to prove a permanent disfigurement or a loss or impairment of a bodily function. How would the pictures after the fact, they can't show permanency, so aren't they?
Well, they may if there was scarring, and scarring under the case law would constitute it. And this is where we get into, as judges and as attorneys, I do trial work too, and this is where we get into the issue of, we know the case law, and the jurors don't. And whenever I decide whether, or give counsel as to whether I'm going to try a case or not, I'm resisting arrest. The mere tensing of the muscles constitutes resisting arrest. And I look at it and I say, God, in an appellate issue, this is a slam dunk. The officer is going to testify that he tensed his muscles. But to the lay person who's not cognizant in the case law, to assume that, I think, is error.
But I'm back to Justice Lowy's point, though. I mean, we don't want to exclude blind jurors unnecessarily. And in this case, seems like a good case where there isn't going to be anything here that requires, sight. Isn't this, if this case doesn't meet the definition, which ones do?
With all due respect, Your Honor, I would suggest that the question should not be framed at that, but the question should be framed as to whether the sufficiency of the evidence or not is one aspect, but whether Mr. Heywood did receive a fair trial under Article 12 and the Sixth Amendment by the inability of the juror to be able to
See what?
see the pictures of him immediately after the assault,
But again,
see him on the stand.
Can I just push you just a little bit?
Sure.
So the picture, we know he's not permanently scarred, right, from other testimony, correct? So what's the value of pictures that might show he was scarred when we know he wasn't scarred?
It would not be I don't believe that it would be premised that way. Serious bodily injury can include a lot of things, and the mere initial disfigurement, if there was any of the jaw in and of itself, may very well have constituted, or if there was not any initial disfigurement, may not have constituted in this juror's mind serious bodily injury. And again, we don't know what his experience in life is. And if you say to me, well, a guy, you know, this guy got assaulted and he's got a pin in his bone, from what I have seen in the 90s, in the violence in Miami, to me, that is not serious bodily injury. I know the case law is different, and that's where we run into the trouble that we analyze it from our perspective, knowing the case law, and a juror does not. A juror just takes his life experiences, and we don't know what this juror's life experience was or was not.
Wasn't the time to find that out at the time that you could have lodged an objection and the judge could have actually made further inquiry? I mean, you
It
know,
was.
we put the judge in an untenable position.
I do not believe that trial counsel in this situation acted in Mr. Heywood's best interest by not inquiring further and lodging an objection, especially when there was demonstrable evidence that was going to be presented. If this was a slam dunk case and the Commonwealth thought this was a slam dunk case, specifically just from the testimony in and of itself, then would they have submitted the pictures? Would they have submitted the medical records? You know, was that just the cherry on the hot fudge sundae or not? And
Are you saying it's because he couldn't read the records either? Is that it's the records as well as the pictures?
Yes, yes.
Well, somebody could read the records to him, right?
Someone can, but then again, we get back to the point that I made, that how do we know that the person read the records correctly? Are we assuming that he did? Are we relying on other jurors who may have observed it, or were they talking to other jurors discussing other issues? We don't know what goes on in a jury room, I would suspect, because most of us have never sat in a jury room. But this goes down to the fundamental issue of Mr. Heywood's fundamental issue of a fair trial, I would suggest to the court, trumps any analysis on the sufficiency of the evidence.
So by your logic, if it turns out that a juror is illiterate and therefore needs others to read things to him or her, same result, it would be a structural error?
You know, Judge, I can answer that from a personal perspective. I have a 9-year-old that's profoundly dyslexic. Would I trust my son to be able to go in at the stage he is now, reading at a beginning of a first grade level, being in third grade, go in and read medical records or any records, and would I feel comfortable that he could be a competent juror? No, I think there has to be some minimal level. And in this situation, in this case, when the judge could have struck this juror and allowed him to sit on any number of other cases that were probably being held that day within the courthouse within Suffolk County, the judge erred.
All right, thank you.
Thank you, Judge.
Ms. Campbell?
Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. I'd like to acknowledge the amicus that was filed in this case by the National Federation of the Blind. Massachusetts law makes clear that no person shall be excluded from serving as a juror due to their membership of a class. And that is essentially what the defendant is asking you to do here today, to exclude blind people from serving as jurors. Now, he says that he doesn't, but he then says in any case that has photographs or records, a juror would have to be excluded, and that simply isn't the case. Before I get too far down that road, I think it's important to determine what the precise question that this court should be answering in this case, which is, in this instance, whether the judge abused her discretion in determining that this juror, juror number 6, was qualified to serve as a juror in this case. And an abuse of discretion standard necessarily asks whether this judge's determination was outside the range of reasonable alternatives. And looking at the facts of this case, as the court must, because General Law Chapter 234A, Section 3, states that it's a case-by-case determination, the judge absolutely did not abuse her considerable discretion in determining that this juror was qualified to sit on, competent to sit on this jury. Now, I think it's critical that defense counsel in this case did not lodge any objection. He did not move to strike this juror for cause, and he did not use a peremptory challenge, even though he had peremptory challenges that he could use. More important than that, though, the judge absolutely did the inquiry that she was supposed to do. She brought it to counsel's attention. She asked the Commonwealth what type of evidence that the Commonwealth anticipated it would submit in this case, and the Commonwealth explained that there were 2 photographs. Now, there are a number of questions about the photographs, and I think that this is the photographs themselves, as related to the evidence and the elements of this case, demonstrate why a juror, any blind juror, could sit on this case, insofar as it wasn't contested by the defendant that an assault took place or that the victim in this case sustained injuries. The only attack was that these injuries met the legal definition of substantial bodily injury. And these photographs, standing alone, could not meet the elements of those crimes, of the crime, insofar as it simply showed what this victim looked like shortly after the attack took place. The Commonwealth, in either opening or closing, does not point to those photographs and say that these photographs show or demonstrate that this victim, standing by themselves, sustained a substantial bodily injury. And I think that's important because it's not, if you look at the case law, and not that there's a case directly on point, but if you look at case law that looks at key pieces of evidence, what is necessary is that, and I'm relying primarily upon Susie, what is necessary is that the pieces of evidence that the juror could not see were key to determination of the very key critical factual issues in this case. And that's certainly not the case here.
Can I ask, do we know what theory it went under? Because is it a substantial disfigurement, or is it a loss or impairment? Or
I'd argue both.
Permanent disfigurement or loss of a function? Do we know which one it was, or we don't know?
We do know. If you look at the Commonwealth's closing argument, and it's inartfully phrased, I would say that it supports that it was both. It says permanent impairment, but the facts that the prosecutor points to are both the insertion of the titanium plates themselves and the impairment to the skin, which is an organ.
How do you see the permanent disfigurement? I see as being a little more complicated. Especially, I guess this was like a subtle indentation or something like that?
Before, the victim himself testified, both on direct and cross-examination, that after the attack he had an indentation and that the titanium plates were necessary to maintain his facial structure. The way that it was described, I don't think it's that complicated for a juror to understand.
But so, by the way, is that correct? Could that be a permanent disfigurement?
Yes.
A slight indentation?
Well, no, I think it's important to look at the evidence as to what that indentation was, which is that titanium plates were actually necessary to maintain his facial structure. I would say that that would qualify as a substantial bodily injury under the statute.
Which one? Which part of the statute does that cover? Does that cover the loss of a bodily function, limb, or organ, or does it cover substantial disfigurement?
Permanent. the permanently disfigured.
So if they can recreate your face perfectly, but underneath it's done through like, all I'm thinking of is a hip replacement.
Sure.
So you get a hip replacement and no one knows, well, maybe you have big scars, I don't know enough about this, but, so your face looks exactly alike, but it's done based on a artificial part. That would be a permanent disfigurement, permanent disfigurement. It's a question, I just don't know the answer to that.
Yes, I believe so, and I would point to specifically the Rainey case and the Sigmund case, which are cited in the Commonwealth's briefs, which are unpublished cases from the appeals court, which talk about, I think an analogous situation is that if you have a tooth knocked out and you have a prosthetic tooth implanted, that qualifies under the statute for purposes of substantial bodily injury. So in the same way as if there's something implanted in your face which is necessary to maintain the structure of your face, I'd say that's the same.
How about the loss of bodily function? Is that the lack of feel in the face?
Correct, not the loss of, it's either loss of bodily,
Feeling?
the numb feeling. He described it as feeling as if he had been
Yeah.
shot with Novocaine,
Right.
And that he didn't have feeling at all. I'd say it's not just that, though. He also testified that every day that he went to work, because it was colder in his office, he would have to use a hot compress on his face because of the pain and discomfort that he felt due to the insertion of the titanium plates in his face.
So if I had a chipped tooth and they knocked it out and put in a really nice replacement one, I've got a permanent disfigurement in my face?
Correct, according to the appeals court.
According to the unpublished.
According to the unpublished appeals
So
court.
so is you're telling us that we have no published appellate case law as to whether we look to what happens before medical care kicks in as opposed to after the medical care kicks in?
I don't believe so. I don't believe
I'm
so.
sorry, I don't believe so, meaning which do we look to it before the hip replacement or after the hip replacement? If somebody basically knocks,
Before.
if somebody knocks a person down, breaks their hip, person then goes and gets a hip replacement and it's as good as or better than it was before, is the person guilty of having committed serious bodily injury?
Yes, I think you would look at it before. If you think of causation, it's the but for the intervening injury, would you have suffered this harm? In this case, I don't think that question is necessarily dispositive, where you do have the other avenue, and the Commonwealth proved both with the loss to the sensation in the skin, which is an organ under the law. I think that separate avenue would satisfy sufficient evidence under the statute as well.
So the numbness of his face constitutes an impairment of an organ.
Correct. Not just the numbness of, I would say the numbness coupled with his testimony that every single day when he's in his office, it's cold in his office, he has to put a hot compress on his skin in order to be able to function.
So going back to the issue of blindness.
Yes.
Do I hear you accepting conceptually the idea that there are some cases for which visual observation is so critical that it's appropriate for a judge to say this is not a case that a blind person can serve on?
Yes, and I think a good example of that would be the Susie case, because in Susie there's an eyewitness who describes the assailant as having perfectly even front teeth. And I'm not sure, and maybe there is a way and I just don't understand where it would be, but I don't understand, aside from the visual observation of, and the defendant in that case was asked to show his teeth to the jury in court during the course of trial. I'm not sure, aside from being able to make that visual inspection yourself, how you could come to that critical determination in...
Gloved hand.
Yeah. Yes, that's a good example as well. And I couldn't see how you could describe, if you had a person, even one of the interpreters, they would necessarily, if they were to be describing this individual's teeth, say, oh, the teeth are perfectly even, which...
Does not preclude a number of cases, because as you well know, the first thing the police do after there's a serious crime, grab every piece of surveillance video they can find within a certain pathway, and that becomes, on Fridays in this court, critical evidence. Are you saying that blind jurors couldn't sit on those types of cases?
I think, again, it's important to remember the case-by-case nature. Though there may be surveillance video in a lot of those cases, sometimes it's not necessarily that critical to the case itself.
The amicus doesn't want, they're not suggesting, this develop as a matter of common law because of, the unfairness to certain citizens of not being able to participate in jury duty. And some of these cases that we're talking about would be really hard cases. So why isn't that a study group idea a good idea?
It could be a good idea.
Because how often are we going to get the perfect case?
Absolutely, absolutely. No, I think the BBA wrote the letter, and I think that is a good idea to look at the barriers to access of people to serving on juries.
You want us to decide this case because it has, in your favor, because it has a description in medical reports?
Correct.
And is it your position that the medical reports, if, to use my hypothetical, if I read them and someone else listened, that's not extraneous?
No, that's not extraneous, and I'd say if that definition is accepted as extraneous, then you'd have to throw away probably every single verdict that comes down, because who knows what happened. I've never sat in a jury deliberation room, but that seems to me like a normal deliberative process that would go on. I would also say that in this instance, there were a number of medical records, and the jury rendered a verdict in a very short time. So this isn't a case where they were out for days and days. So it doesn't seem that the factual situation of how the verdict was rendered doesn't lend itself that they were poring over these medical records anyway.
Now, the statute simply says that a physically handicapped person shall serve except where the court finds such service is not feasible.
Correct.
Is that the standard? Yeah, that's not a great standard, and because the question is, what does it mean to be feasible?
Sure.
Do we need to craft a due process overlay to that?
Not more so than you already have done in the Susi case, in which you talk about how a judge should, on a case-by-case determination, look and see if an individual juror is competent. Not more so than exists in the statutes, reading the jury statutes sort of in combination, as I do in my brief. But certainly when you look at the facts of this case, there's no basis to conclude that the judge abused her discretion in letting juror number 6 sit. I'm happy to answer any further questions, but...
Normally we look to reasonable accommodation in other contexts to decide whether someone can do the task. Is that a proper standard here, that whether the juror can, with reasonable accommodation, evaluate all the evidence? Because I take it they have to be able to evaluate all the evidence, right? It's not like we don't like jurors who miss parts of cases because they're asleep or something else.
Sure.
So
Sure.
is that the standard?
That sounds like that would be a reasonable standard, but I also think that it's incumbent, in this instance, the silence of defense counsel to object, it doesn't lend itself, like my brother suggests, to the type of structural error which leads to automatic reversal. And this case shows why. Even if there were some sort of, not that this case presents this, but hypothetically, even if there were some sort of problem with the way that the judge evaluated the competency of the juror, then the defendant should still have to show prejudice, because it could be that the evidence that a juror could not see wasn't key evidence and wasn't necessarily necessary to render the verdict, given the way that the case was litigated.
I was just going to say, I understand the reading of medical records, but what about the describing of photographs? Do you see that a problem with that, for one juror to describe photograph to a blind juror?
So not necessarily. I could see how it could be, because you could subjectively put in your own description. So I see how that could be more problematic than the simple reading of a record. Again, I don't think that makes any difference here. And I think that's where the amicus comes in, where they talk about accommodations that could be made, and that there are interpreters, site interpreters, which could offer that function.
Is the judge's emphasis on the jury taking over this sort of maybe not the right emphasis we want to place, that rather that we should be focusing on the court stepping up so that the jury doesn't have to do too much of this? Here's
Sure.
what the picture said, right?
Sure.
Yeah.
Yeah. And if the court has no further questions, the Commonwealth will rest on its brief.
All right, thank you.